authority granted by the Constitution for the President to establish an organization or an entity that deals with constitutional change. That is the mandate of Parliament. He was acting beyond his jurisdiction. He did not have jurisdiction, devoid of his jurisdiction. Consequently, he was not performing official presidential functions. He was performing his own private business, the business of trying to change or overhaul the Constitution of Kenya without authority from the Constitution. Therefore, he was not acting in his official capacity. Despite purporting to do so, he was acting in his own personal or private capacity. And that is why I sued him in his private capacity. That's why I sued Uhuru Muigai Kenyatta, not President of the Republic of Kenya. Consequently, because he purported to act as President of the Republic of Kenya, using the authority of the state of office of President of the Republic of Kenya, contravening Article 2.2 that prevents anybody from exercising state authority unless you have authority under the Constitution. He was basically abusing his office. And that abuse of office is a contravention of Chapter 6, Article 73, Clause 1A, Roman 1. And that is why I sought that particular declaration against him. And it is not the first time that these courts have found declarations of contraventions of Chapter 6 against Appellant Uhuru. The very first time it happened was in 2012. Those days used to be chairman of KANU. 4 KANU members got tired of KANU's inactivity. So they took him to court in Mombasa. I believe that is Mombasa Constitutional Petition number 17 of 2010, 2 months after the promulgation of the Constitution. Eventually, a decision came around October 2012, and Uhuru was found to have contravened Chapter 6, specifically Article 77, Clause 2, being an appointed state officer and holding office in a political party. He refused to resign his office in KANU, and he remained the Deputy Prime Minister, Minister for Finance. Those are appointive offices, and therefore he contravened Chapter 6. And there is a Chapter 6 contravention, holding against Uhuru, Appellant Uhuru even today. This issue was even raised to IEBC before the 2013 general election. IEBC just ignored them. Maybe they fear dealing with Appellant Uhuru or whatever. And so Appellant Uhuru is now president, though if the law had been followed, Uhuru would never have been president, because that finding of Chapter 6, which he never appealed even to date, how many years down the road? 9 years down the road, he's never appealed it. It's a valid Chapter 6 finding against him. So one wonders, why is he making so much noise about a Chapter 6 finding against him, this BBI issue, when there's already an existing Chapter 6 finding against him, in that case from Mombasa, and another Chapter 6 finding against him in my case in 2016, the one that I referred to earlier on. So I'm just wondering why he's making so much noise. Maybe those ones didn't have the high profile. And this one, because BBI, everybody in the country knew something was happening, he decided, no, too many people know about it, I'll come and defend myself. But my point is, whether or not the finding of, on Chapter 6 in this particular matter is changed or not, there are still 2 existing Chapter 6 findings against him, and despite that, because he has contempt for this Katiba, he's still president, and nobody's doing anything about it. That is the state of Kenya, contempt of the Constitution by Appellant Uhuru. And this is the thing that some of us don't like. And I think something we need to get clear over here. Appellant Uhuru is not the sovereign of this country. We, the people, are the sovereigns of this country. Issues of doctrines are not sovereign immunity. Those sovereign immunity doctrines do not apply to Kenya. If sovereign immunity doctrine applied to Kenya, there'd be no court. Because I, as a sovereign, you can't sue me. And you, as a sovereign, I can't sue you. Nobody could sue anybody else. The dispute resolution business would be dead. Because all of us would have sovereign immunity, because we're the sovereigns of Kenya. So don't tell us Uhuru is a sovereign of this country. No, Appellant Uhuru is not sovereign of this country. He is a subject of us as sovereigns. We're the ones paying his salary. We're the ones appointing him. We're the ones delegating our power to him. He is our employee. Maybe the most senior employee, but still our employee. And when he goes off the rails, we come here to discipline him. Therefore, when you're talking about a declaration against him, that is just to discipline him. It's a slap on the wrist. We haven't yet kicked him out of office, but at least we're disciplining him. There you've gone overboard, our employee. Employee number 1, Appellant Uhuru, you've gone overboard. And that is basically, that's what we're doing over here. So we don't want any nonsense being told he's sovereign immunity. Outside Kenya, because of diplomatic conventions, we don't mind, he can ride with sovereign immunity. But here at home, he must know that we are the sovereigns He is a servant of ours. And he must do what we agreed to do in the Katiba. And that is basically what we're fighting for over here.